Good morning. I'm Carlo Alberto Giusti. I'm the legal advisory for the international affairs of the Italian Minister of Justice. First of all, I'd like to thank you, the European Criminal Justice Observatory, to make it the possibility to share with you a few short consideration about the role played by the Bank of Italy in the fight against economic crime and the fundamental cooperation between the Bank of Italy and the Unit for Financial Information with the judicial authority in the fight against economic crime. Well, in line with the recent European directives, economic crimes must be combating by pursuing both the objective of law enforcement and that of economic development. A balanced strategy of prevention and suppression must be found upon rules that, on the principle of the proportionality to the threat, lay down clearly formulated and easily applied obligations that avoid instruments, intrusive and rigid procedures that do not overburden honest businesses, that institute mechanisms of enforcement and sanctions that are swift, effective, and proportionate to the seriousness of the infractions, that provide incentives for intermediaries to collaborate with the structures that fight money laundering, and, in conclusion, that strengthen domestic and international cooperation among authorities. Well, the states that are most aware of the problem, perceiving that the criminal organizations are most vulnerable where they seek to pass the proceeds of crime into legitimate channels, have long concentrated their efforts on the protection of the financial system. Given the nature of its activity, the financial system can be exploited to launder the proceeds of the crime, but at the same time, it has proven to be highly effective in cooperating with the law enforcement authorities. Different institution players are called to collaborate and cooperate to enforcement of the rule of law in the financial sector and to contribute to the achievement of the results set. A major role is played by the judiciary, by the supervisory authorities, the financial intelligence unit established by at the Bank of Italy, and by the investigation authorities. Well, in the context outlined, the Bank of Italy contributes to the compliance with the rule of law in the financial system, also through the protection of transparency and fairness in the relations between intermediaries and customers that, from the regulatory viewpoint, is a full party of the purposes of supervision. Also in this sector, moreover, the coordination between the Bank of Italy and the judicial authority is strategic and represents source of synergies. Indeed, if the judiciary is called to settle the disputes on legal assets of relations between intermediaries and customers, through law enforcement on single cases, the private enforcement, the action of Bank of Italy public enforcement protects, conversely, the public interest in the case of transparent and fair relations between intermediaries and customers, with the ultimate aim of promoting fair competition, mitigating legal and reputational risk for intermediaries, and ultimately supporting customer confidence in the financial system as a whole. More in detail, the supervision activity may highlight different types of offenses involving banks and other financial intermediaries, generating a specific interaction between the supervision and the criminal justice. Well, it's useful to group the criminal phenomena that can be highlighted during the supervisory activity into four different categories. Two thieves, belong those conducts that hinder or hamper the supervisory powers and those that are related to not authorized banking activity and linked to illegal activities. In second can be grouped the offenses that have an immediate impact on the sound and prudent management of intermediaries, including the reputational risk to which they expose them, such as misconduct in relation to corporate assets and infidelity sheets, crime related to the conflict of interest and embezzlement. Well, bear in mind that the underlying of illegal conducts often emerge is the result of the supervision activity. So it's easy to define as fundamental the role played by the Bank of Italy to the assessment of eventual offense in fight against economic crimes. The third group includes offenses such as money laundering and usury, for which the Italian law envisages a specific role and a specific responsibility for the Bank of Italy and for autonomous body called FIU, the Unit for Financial Intelligence. Indeed, the international standards for preventing and combating money laundering and financing of terrorism envisage the institution in each country of a financial intelligence unit charged with receiving and analyzing reports on suspicious transactions and other information related to money laundering, transmitting results to the competent body for the subsequent investigations. The FIU for Italy was established in 2008. It performs its functions autonomously and independently using financial, human, and technical resources seen by the Bank of Italy. Finally, the fourth group includes crimes such as tax evasion or related to corruption, which although are not specifically related to the financial activity, but may involve the top management or the board of directors. Well, the short description could provide a clear perception of different cases of illegal conducts that can be discovered during the supervisory activity and the fundamental role played by the Bank of Italy to prompt inform the judicial authority in case of suspected behaviors. Well, on general remarks, it's important to remember that the supervisory authority cannot research or investigate any illegal behavior adopted by banks, brokerage firms, and private persons and not have the mandate to conduct investigation for acquiring the sources of evidence of criminal behaviors and the identification of perpetrators. All those powers are typically part of judicial power. They are in the hand of investigations authority. Also, during the inspections, moreover, it is legitimate just to ask for information and documents of its interest to the supervising entity that has no power to collect autonomously. If, however, the Bank of Italy detects possible offenses, the Article number 7 of the banking law provides for the obligation of exclusively reporting to the governor and board of directors all the irregularities discovered during the investigation. In the most relevant case, the financial units involved do not limit its activity just to provide to the highest level of the authority the essential data, but they carry out the necessary in-depth analysis aimed to support on technical level the criminal relevance of the facts, with the aim to provide to judicial authority the more detailed reports in order to effectively coordinate the supervisory activity with the interpretation of the judicial authority. So it's easy to infer, therefore, that the intensity and the quality of the institutional cooperation between the supervision and the judicial authority represent an essential and fundamental element to achieve an effective prevention of illegal activities, since the exchange of information on different skills. In recent years has been reported a strong increase in cooperation with the judicial authority, and the Guardia di Finanza recently entered into a protocol. Well, in statistical terms, it's worth to underline underline how in the last year the assignments for technical consulting conferred to the staff of Bank of Italy amounted to 63 as compared to 36 assignments in 2012. The witnessing of institutes employ concern of 48 criminal proceedings, 32 in 2012, and the request for information and documentation made by judicial authority relating to investigations that directly or indirectly involve supervising terms reached 500 units, 9 more than in previous years. The practice, also informal, which have been consolidated and refined over time, have led to establishment of an effective system of collaborative relationship. So it's happened that were introduced structured forms of cooperation in order to provide continuous support to investigations bodies through the establishment of a unit supporting the judicial authority. In particular, in Milan has been operating for some time with excellent results, a pool of experts dedicated to the inspections service purpose. On the basis of the positive results achieved, a similar unit has recently set up in Rome. Well, it's useful to report to a recent question time discussed by the Italian Parliament about the role played by the Bank of Italy's experts supporting the judicial office. The role has been defined as fundamental for the fight against economic crimes. They perform in an independent and autonomous way as financial advisors without having access to the Bank of Italy's database and private financial database. It can be useful to report that the timeliness of information by Bank of Italy to the judicial authority often, especially matters of greater urgency, advanced the delivery inspection report to the supervised entity. The efforts made by supervisory authority have contributed to a recent reform of internal practices, moved to the simplification of operating without compromising the breadth of the evaluation. This in order to avoid to provide the excessively short warning information, but to ensure the most detailed files to support at technical level the investigation of judicial authority. Well, a consolidated procedure by some prosecutor offices also involves providing a feedback on the reporting said by the Bank of Italy, which extending the information in the hands of supervisory authority and represent a suitable supporting guided assessment of new cases and a valuable aid in guided evaluation of new cases. Well, these feedbacks may represent the precondition to adopt the necessary administrative actions. The regular and continued dialogue between supervisors and prosecutors allows to better focus on areas of mutual interest and ensure completeness and decisiveness to the alerts. Well, recent experiences highlighted several situations in which the timely contacts with the judicial offices allowed to start closer monitoring on single intermediaries. In the most critical cases, collaboration allowed to promptly adopt several measures. Well, in conclusion, it can be useful to report that from last November, banking supervision is conducted at the European level. Banks identified as significant are subject to centralized supervision with the coordination of the European Central Bank and the participation of the national authority in approach based on shared responsibility. Lastly, with the startup of the single supervisory mechanism, the European Central Bank will flank the national authorities in exercising the powers of macroprudential supervision, directing to ensure the stability of financial system as a whole. Well, the centralization of supervisory function overlays a set of rules composed of provisions, some of which are common to all unions, some are national, and some subject to minimum harmonization. Producing this framework is a difficult exercise requiring time and effort, but is indispensable for a truly integrated European banking level that presupposes uniform rules and unequivocal definition of banking. This will be fundamental to the success of the banking European Union. The inception of a single supervisory mechanism will must take in account the discussion about the European Public Prosecutor's Office that will be analyzed by the new European Commission. The European Public Prosecutor's Office will be an independent union body with the authority to investigate and prosecute European Union fraud and other crimes affecting the Union's financial interest. It will combine European and national law enforcement efforts in a unified, seamless and efficient approach to counter European Union fraud, where currently only national authorities can investigate and prosecute EU fraud. Their competencies stop at their national borders. Existing union bodies such as Olaf, Eurojust and Europol do not have and cannot be given the mandate to conduct criminal investigation. The European Public Prosecutor's Office will fill this institutional gap. It will have exclusively EU-wide jurisdiction to deal with the suspicion of criminal behaviors falling within its remit. Well, the necessity of dialogue between the supervisory authority and the judicial authority is definitely demonstrated, as well as the great benefits provided at national level to the financial system. For this reason, it must be a fundamental effort for the European legislator to find the best way of cooperation between the European Central Bank and the European Public Prosecutor's Office. Thank you very much.